All right, welcome to the House Judiciary Committee this Tuesday morning, March 10th. And today is the miscellaneous judiciary bill day. And so we will have a walk through this morning, and then this afternoon we'll have, and we hopefully will get to at least one witness this morning as well. This afternoon we have a number of witnesses, and then we're looking at another bill that we'll look at and have some testimony and decide whether we're going to put it into the miscellaneous bill. But that's H 629. It just wasn't in the draft yet, and we have to decide we want to put it there. So over to you, Eric, for a walkthrough.
Yes, thank you. And good morning, everybody.
Good morning.
Morning. Thank you. Welcome back. Eric Fitzpatrick with the Office of Legislative Counsel here to do first a walkthrough of the annual miscellaneous judiciary bill. Sure, the committee remembers this is an annual bill that not only does this committee look at a miscellaneous bill, there's a number of committees in the legislature that have a miscellaneous bill every year, and the judiciary committees do as well. It starts in the House or Senate, rotates every year. This year it's beginning in the House as it started in the Senate last year. It's generally an attempt to include provisions that are sometimes more technical in nature or at least minor in nature. And they come up during the course of the year, during the interim. I will get emails from various folks asking for technical pieces or minor corrections to include. They could be from the Attorney General's office. It could be from the state's attorneys, the Center for Crime Victim Services, the Bar Association, et cetera. All sort of send me emails during the year, and I keep them in a folder and then try and put them all together in this bill. So when I do the walkthrough, I will note where the request came from so that everybody knows, oh, this is who asked for this one, and that's why that one's being included. So try and at least, and in some cases, actually, there's a few places here and there where it's just some technical correction that our office noted that during the course of revising the statutory volumes, we came across it, so I'll put it in the same folder and hang on to it until the miscellaneous bill walkthrough comes around, which is right now. So I'll mention those as well when I go through them.
So before you go, just one other quick thing. Sometimes there are things slightly more than technical, and kind of the standard that this committee has used is that they're not too complicated. Some of these might be complicated to us, but not necessarily to the presenter, because there are a couple things related to probate, real estate type there. But as long as it's relatively not complicated, there's not controversy over it or minimum controversy, and we can have a unanimous vote in here, then we can include it in the bill. So it's kind of the standards that we've been following.
Yeah, that makes sense. It's been that way for a number of years now. So I think you're right. It's definitely not always necessarily purely technical.
Right.
But as you say, relatively straightforward. Everybody agrees, that sort of thing.
Yeah, right.
All right. So having said all that, I'll do a quick walkthrough of the different provisions, and there's a number of them, and you'll see they cover a lot of different areas of the law. I'll try and give you a little bit of explanation so you understand what's going on in each section. So the first one, section one, this was, the first section was requested by the Center for Crime Victim Services. And this, you'll see, it looks like a lot of new language there because the first 3.5 pages are all underlined. It's not brand new, it's just moved from one section of law to the other. So there's no changes, it's verbatim. And the provision that's being moved has to do with something in existing law related to profits of crime. So there's an existing law that permits the Attorney General or a crime victim to bring a lawsuit to recover profits of crime when someone who's been convicted of a crime, for example, tries to write a best-selling book or something like that. That just sort of used the classic example. That was the reason that many states have these kind of statutes now. But the Vermont Profits of Crime statute, even though it's the Attorney General that administers this program, is located in the crime and the Victims' Compensation Board's chapter of Vermont law. So all this does is it moves the Profits of Crime subchapter from the Victims' Compensation Board area of law to the Attorney General's area of law in the Vermont statutes. And my understanding is that both the AG and the Center for Crime Victim Services and the Victims' Compensation Board have all agreed on this change, that it makes sense for it to be located here rather than in VCB statutes. So that's the quick summary of that, why that language is all there as opposed to where it's being repealed, which we'll see later on in the walkthrough. So that brings us over to page 4, section 2. This was requested by the Court Diversion Program and the Attorney General's Office. And what's going on here is that under current law, you may recall, you've talked about it in this committee quite a bit, there's a civil violation on the books for minors doing various things related to alcohol, tobacco, cannabis, that sort of thing. And so the civil violation under existing law sort of starts on page 4, carries over onto page 5, and that's for things like if the minor buys alcohol with a fake ID, if they possess alcohol, possess cannabis, consume alcohol, et cetera. That's A through D. And then you see subdivision E there on page 5, also operating a motor vehicle at .02 or above. So this proposal, as I mentioned from court diversion, is that the way the current law is structured, one of the penalties that can happen for one of these minor civil violations is that the minor's driver's license is suspended for a certain specified period of time. But there's an automatic renewal after that period of time. If it's 90 days, it gets automatically renewed after 90 days. For some reason, not sure exactly why, that automatic renewal piece is only in place through A through D from pages 4 to 5, what I just mentioned, using a fake ID, possessing alcohol, et cetera. Those things, I'm sorry, I got it opposite. It's only in place for subdivision E, the .02. This automatic reinstatement. The automatic reinstatement.
Questions?
Especially on the DUI, I thought there was I thought they had to go through diversion. I thought we made that a law.
That is down there. Yep, line 18. That step, they are referred to the diversion program. And
they have to pass that before they get it's not automatic they're going to get their license back, is it? Unless they pass that course?
That's right. If they don't pass it, I think though what happens if they don't pass the course, then they get the civil penalty. That's when they get the $300 civil penalty and the license suspension. But yes, there is an automatic reinstatement. That's a proposal. Actually, no, that's the existing one under subdivision E. So yeah, there is an automatic reinstatement currently. I think Willa from the AG's from the court diversion will be able to give you a little bit more detail on that. But I believe that there is one currently.
Okay.
So yep, and the proposal here is to parallel that and have the automatic reinstatement also in place for those first 4 civil violations that I mentioned, using a fake ID to buy alcohol, possessing alcohol, etc. And you see that over on page 6, lines 5 and 10. So that's the proposal there. And you may have noticed too, if you look at that, going back to page 4 again, because on line 9, these civil offenses only apply to a minor who's 12 years of age or older and under 21. And that makes some sense if you think about it, because juvenile offenses also only apply to 12 years and up, right? That's the minimum age for a juvenile offense. Again, though, there's for this one, which is the alcohol one, if you look over at section 3, page 6, these are the civil violations for tobacco products. Those apply to anyone under 21. That's line 13. It doesn't have that same language of it applying only if the person is 12 years of age or older. So again, this was a proposal from the judiciary to make that consistent so that in both the alcohol, cannabis, and tobacco context, these violations only apply if the child is 12 years of age or older. Under that age, the child could still be subject to a CHINS petition, child in need of care, supervision, that sort of thing, but it wouldn't be subject to a civil or criminal offense. So that's what's going on in that section. Page 7, section 4 starts at the very bottom, continues over on page 8. This is purely technical, something our office noticed. It's just a missing conjunction. Line 6, page 8. See, that's a missing and, so that's inserted there. Section 5 is actually something that this committee has worked on before earlier this session. This was H572, which I think the committee heard testimony about. This section repeals the law that prohibits public access to internet criminal records. So you see, if you look at existing law, lines 11 and 12, right now the court can't permit public access via the internet to criminal, family, or probate case records. So the proposal is to strike criminal so that the public would be able to have access via the internet to criminal records And if you look at lines 19 and 20, the court is required to develop rules to establish how that's going to work.
So really quickly on that one, we're not going to have additional witnesses. We had a bunch of witnesses this as a separate bill earlier, and there didn't seem to be any controversy, and everybody at that point seemed to be on board with that. If we do want to hear from Judge Zone again, we can have him address that. But we have taken witnesses from a number of individuals earlier in the session.
Great, sounds good. So moving on to section 6, also purely technical. In this case, you'll see line 13, there's a reference to the district court, which doesn't exist anymore. After the judicial restructuring in the late 2000s, the district courts were eliminated, and they're all superior courts now, so that terminology is updated. The section 7 was a request from the judiciary, and this you'll see some language being repealed, bottom of page 9, lines 19 and 20. This is also a case of an oversight years ago in 2011 when the mortgage foreclosure statutes were restructured. They were placed elsewhere in Title 12, and that section that you see repealed right there already exists in this other section of Title 12. So we don't need it twice. So it's being repealed here and remains in the revised mortgage foreclosure statutes or elsewhere. Turning over to page 10, this also is actually the next two sections, sections 8 and 9, page 10, 11, and 12. These all enact a House bill that you have on the wall that was introduced this year, H 873, which refers to stalking cases. You remember stalking cases are both criminal and civil. You can have a criminal prosecution as well as a civil order against stalking. And in the course of proving a stalking case, one of the requirements is that there is a course of conduct. So if you look at the key line there, it's line 5, page 10. Course of conduct means 2 or more acts over a period of time, however short. So it can't be just one act, it has to be 2 or more. The proposal is to make clear, look at lines 19 and 20 of the same page, page 10, that course of conduct shall not be construed to require that the 2 or more acts occur on separate calendar days. My understanding is that there have been some court decisions that suggested that the 2 acts have to occur on different calendar days. So this is clarifying that these 2 acts don't have to be on the same day. They can be any 2 acts, or 2 or more, I should say.
Just really quickly on that, this comes from a bill that introduced by Zach in H 873 that puts language into this bill.
Right, exactly. And the same for section 11, which starts on page 7. What we just looked at, section 10 was for civil cases. Section 9 on page 11, section 9 is the same change for criminal cases. So if you turn over to page 12, line 6 and 7, you see there it is, that same language being inserted. Course of conduct not construed to require 2 or more acts on separate calendar dates. Moving on to section 10, bottom of page 12, purely technical correction, a reference to section, which should be subchapter. Over on to page 11. Now this is from the Center for Crime Victim Services, section 11, page 13. So under existing law, there's a requirement that when a law enforcement agency is investigating a crime, they have to provide certain information to the crime victim. And you see that information is listed on page 13, subsection A there, line 3, all the way down to line 1, 2, all 3. That's all in this list of information that the law enforcement agency provides to the victim. The proposal here is to add one item to that list of information that is provided to the victim by a law enforcement agency. And you see that at the bottom of page 13. It's information concerning the victim's right to know if the defendant is held at a correctional facility, where the defendant is held, if the defendant is released, how to locate the Department of Corrections Vermont Offender Locator website, and how to register for automated notifications when a defendant is released. All that exists. This is providing the victim with information about how to access it, basically. And my understanding is that that information is already in this form that law enforcement agencies provide. So you're sort of basically making the statute reflect what's already in the form that agencies have been providing. All right. that brings us to page 14, section 12. This is what I mentioned earlier. This is part of the current profits for crimes statute that is in the Victims Compensation Board statutes. So it's being repealed here. You see that? Because as we saw in the very beginning, it's being reenacted in the Attorney General subchapter. So being moved from one place to the other, not changed in it, just moved. Section 13, that's over on page 15. This was also a request from the Center for Crime Victim Services. This has to deal with the composition of the Victims Compensation Board. Who's on the board right now? You'll see that listed in subsection A. It's established in order to award compensation to crime victims and their dependents. Consists of 5 members appointed by the governor. And the first one you'll see is a physician licensed to practice in this state. I think you'll hear testimony on this, but my understanding is that the board wants to broaden that a little bit. So it doesn't just, could be any healthcare provider licensed in Vermont, not necessarily just a physician. So I spoke with our healthcare attorney about the best language to use in this situation, and that's what you have in line 8.
Eric,
Yeah.
I should probably know, what's the definition of a healthcare provider?
It's any person licensed or certified to provide professional healthcare service in Vermont. Boy, I love it when that happens. I anticipated that question. I wrote it right down here in the margin. Just in case somebody asked that.
Yeah.
Yeah. Appreciate
It's
that.
almost like you've been around here for a month.
Yeah, you'd never know. Thank you. I appreciate that. Teeing it up for me.
And so everybody knows, we didn't set that up.
No, totally right. So yes, that's why that's there. Next section 14, page 15, also requested by the Center for Crime Victim Services, and just another example of the profits of crime piece being moved. So this is listing what the duties are of the Victims Compensation Board. And if you look over on page 16, line 1, very top there, one of the things the Victim Compensation Board has to do now is look at this profits of crime issue that I was just talking about, but they're not going to be doing that anymore. That's moved over to the Attorney General, so it's struck here. All right, now next section 15, page 16, also from the Center for Crime Victim Services. This has to do with restitution. And I think this committee remembers that the way restitution works is when someone is convicted of a crime, the court, generally speaking, if there's any loss suffered by the victim, the court orders that the defendant provide the victim with restitution to compensate them for their pecuniary loss. Now, that's after the conviction. In addition, the way the restitution unit is set up, there's a crime victims restitution special fund. And in many cases, the victim can get an advance from the fund before the conviction. So, yeah, obviously after the conviction, they'd be entitled to recover, if they can, any loss that they suffer. Prior to the conviction, they can get an advance from the fund, but the advance has always been capped, or it used to be capped at $10,000. A few years ago, the legislature lowered that cap from $10,000 to $5,000. However, there are several places in statute where we neglected to make that change from $10,000 to $5,000. So this is technical in that sense. It's just the change was already made a few years ago, but there's a few places we forgot to change the $10,000 to $5,000.
So you can get $5,000 pre-conviction.
Correct.
If they're not convicted, money has to be paid back.
That's an excellent question. I did not have my answer in the margin to that one. That wasn't in history. That's a good question. I don't know the answer. Yeah.
Okay.
Right. What happens if they don't get convicted? Right.
Didn't recognize you.
Yes, I'll look into that as well. It's a good question.
Okay.
Yeah.
Thank you.
You bet.
It would make sense to me.
Right. All right. So moving on now, you'll see page 17. These next two sections actually over on to page 17, 18, and 19. All those sections, they're all being repealed. That's all the profits of crime sections that are in the crime victims chapter of law. So again, those are all just being repealed here and moved over to the Attorney General's subchapter. Over on page 19, you'll see that's another example, lines 14 and 15 of the $10,000 advance cap on the advance from the restitution fund being changed to $5,000, places where we had forgotten to do so a couple of years ago. Another change down at the bottom of page 19. This was a request from the court diversion program, and it deals with the records of pretrial risk assessments and need screening. So you remember sometimes there will be a pretrial risk assessment and a need screening, and currently the records of those assessments and screenings are confidential, and they have to be retained for 3 years. So if you turn over onto the next page, page 20, that's all existing law on page 20. That's just about confidentiality. And then if you look over on page 21, though, line 9, as I said, currently those records have to be retained for 3 years. The proposal is from the diversion program to change that from 3 years to 2 years, which I think is consistent with state records retention policy generally. All right. We're moving on to section 20. I'm interested. So I made a technical change in this late last night, which I didn't print off a new document for myself. So just curious, on line 14 of your document, does it say repeals spendthrift guardianships?
Yes.
Yeah.
Excellent. Mine says spendthrift trust. Oh, thanks. Yeah, my printer at home doesn't work. Yeah, so what's going on here is that, and this is proposed by the judiciary, this is a repeal of all the statutes related to spendthrift guardianships. These are very old types of guardianships. And in fact, the definition, it's an interesting old definition. A spendthrift guardianship is a guardianship for a person, quote, who is liable to be put under guardianship on account of excessive drinking, gambling, idleness, or debauchery. So, yes, those, as you might guess, are not used anymore. These statutes, they're not the basis for guardianship.
Debauchery?
I know, evidently. I know, that'd be a tough one. So those statutes are no longer used as the basis for a guardianship in the probate division. So the proposal from, in fact, this was a proposal from the advisory committee on the rules of probate procedure, that these statutes are outdated and no longer used as a basis for a guardianship petition, so they should be repealed. That's what's going on here.
Nice to repeal some laws every once in a while.
I know, it's true, right. Yes. Over on to page 22. And this one I know will be, this is a proposal from the judiciary that I know will be especially pleasing to the chair, because this is a proposal, as we know, from the day is a day law from years ago that we spoke about earlier this session in the committee when referring to limits on the number of things that have to be done in terms of court procedure. They use multiples of 7 days now. So you'll see in line 15 that the current use of the term of 15 days is as a time limit for when the court has to schedule a review in these types of cases, these contempt cases, is changed from 15 to 14. So I'm sorry, I said multiple 14, multiple of 7. That's what I meant.
So was my heart.
I know, right. There'll be another example. All right, so that was section 21. Section 22, also from the judiciary. Current law, under current law, when there's a child custody determination, this is over on the top of page 23, a certified copy of this, of the determination has to be sent to the court administrator from the family division when this happens. This is also an old law. It's no longer necessary because these sorts of things are just filed directly into the electronic case management system. There's no need to send one by certified mail. So it's an old statute that's being repealed. Let's see, that brings us to section 23, also page 23. This is one in which both the judiciary and the court diversion program both ask for the same issue and ask for the same correction, which is an incorrect cross-reference. You look over on page 24, lines 7 and 8. In fact, we saw this in the first couple sections of the bill, the Youth Substance Awareness Safety Program. That's not located in 4230B anymore. It's located in 7 VSA 656. So it's just correcting that cross-reference. And it does that again on section 24, also on page 24, line 18. So these are just correcting some outdated cross-references requested by both the court and the diversion program. That brings us to page 25, section 27. This is a request from the Vermont Bar Association. And this, you'll see the language itself looks a little complex there, but the principle is pretty straightforward. And just to remind the committee for a second, I know in previous years, previous legislation the committee's looked at, we've talked about the idea of jointly held property. So more than one person can own property together. And there are different ways that more than one person can own property together. And two of the most common ways are what's called joint tenancy and tenants in common. Tenancy in common. The primary difference between these two types of property ownership is what happens when one of the owners dies. If it's joint tenancy with right of survivorship, the two people own property in that way. And if one of them dies, the person who survives gets the full property. So the person who died, their share goes to the other person who's still alive. That's if you own property as joint tenants with right of survivorship. On the other hand, tenants in common, two people own property as tenants in common, one of them dies. Their share of the property goes to that person's heirs. Could be their kids, could be other family members, could be whoever they've decided in their will is going to get any of their property if they die. So it doesn't go to that person who's alive. It goes to that person's heirs. And you can decide as joint tenants however you want to do that. It's up to a person who's creating a property interest to make that decision. So why am I explaining this to you? Because in this section of the bill is in response to a Vermont Supreme Court decision from a couple of months ago, January 2026, called Kirshon v. Abadili Mills, in which the court interpreted, did I just say interpreted?
Yeah, it rolled off the tongue.
I know, I just made up a word there. So what the court found in that decision was that, and it looked at standard language that's in deeds and other property conveyances and has been for decades and decades and decades. And it looked at this standard language and said, oh, when this standard language appears, it creates a tenancy in common as opposed to a joint tenancy. So in other words, the result of that is obviously the person's heirs, if one of them dies, the heirs get it and not the surviving joint tenant. However, my understanding, and you will hear from your witnesses about this, is that that same language, when it's appeared in deeds for all this time, has never been interpreted that way. That in fact, it's been interpreted to create a joint tenancy. So this language, in a sense, restores the understanding of what those words in a deed or other transfer of property do. And then what the understanding had been is that it creates this joint tenancy with right of survivorship, not a tenancy in common, and that's what's going on in this section. Does that make sense? And related to this is the next section, section 26. It applies retroactively. So not just for joint tenancies or I'm sorry, conveyances of property that happened, between the effective date forward, it applies retroactively to conveyances that were made in the past, which as you can understand in the real estate context, that makes a lot of sense because a lot of these documents already exist and have for many, many years. So this is saying even for those documents, and you'll see line 18, notwithstanding 1 VSA 214, remember that's language that we have to use if you're going to apply a law like retroactively. Because in general, newly passed legislation only applies prospective. You can have, the legislature can decide to have it apply retroactively, but you have to say so specifically, which is what we're doing here. So this will apply whenever the property interest known as an estate is created, although it doesn't apply if somebody's already started a lawsuit about it. That's lines 19 and 20. Now, if somebody's already litigated it or started litigating it, then it doesn't apply retroactively to that. So that's the end of that particular piece. So moving over on to page 26, section 27. This is something that was noticed by a member of the bar, a practicing attorney who emailed me and let me know that there's a line 4. You'll see deeds no longer have to be sealed and witnessed. So that's a change that the legislature made a few years ago. And so this stray language here, no longer a requirement, so it's struck.
Can I ask a quick question? So who would be a witness on that one? I don't think I have a notation. Wait,
Actually, I think you already have the witness on the other section. It would be Jim Knapp.
that's Jim, okay.
Yeah.
Thanks.
Yes. Next section, section 28. This is something that Representative Oliver brought to our attention, and this is the this is the an interesting. See line 10 there. Any person who finds goods valued at $3 or more, or takes up a stray beast, you see that in line 11, the owner of which is not known, has 6 days to make 2 notices describing money, goods, or beast. And obviously an older statute. My understanding is that in particular, the Capitol Police have been impacted by this. They find somebody's water bottle, for example, valued at more than $3. What's that? Right.
Closer to 50.
I know, it's true, they're pricey.
What is the definition of a beast?
I don't know. Another question I didn't prepare for.
We decided not to fully revamp that.
Okay, I'm just saying.
This may be a temporary fix. We can take it up some other time, but we don't like that old language sometimes, you know?
You definitely get to report that.
So that raises the value a little bit more, as we say, so that not every minor little thing has to be reported and posted. Section 29 is another example of the day is a day, multiple 7 to 14. Look it over on page 27, line 4, changing a 10-day time limit, 14 days. This was a request from the judiciary. And the effective date is on passage in section 30.
Can you tell, what is 33 VSA 6936 generally related to?
I think it's a modification, maybe of a parental rights and responsibilities or childcare, a child support. But I'm not 100% positive.
Okay.
But I will look at that too as well. Okay, unless it's going to be answered.
For emergency relief hearings in
Okay.
vulnerable adult hearings.
Okay.
In what?
So is this the kind of bill that should take effect on passage, or all of the components should take an effect on passage, or are there any sections that need more time to get out there?
I didn't notice any of those, but I think your witnesses would have a better idea of that. You may hear from some people that they'll need more time, and you can certainly restructure the effective date so that some take on passage and some have a delayed date, whatever you hear think might be the best approach.
Any questions for Eric? So we'll hear from Kim next in a moment, and there may be a couple other things that we may still look at to put in here. One we're going to look at later this afternoon. There's a couple other things that if we do, we'll take those up probably on Thursday. You'll note in the agenda that we have reserved some time for those kind of things. But any questions for Eric on this? All right, Kim, if you could join us. Thanks, Eric.
You bet.
Morning.
Good morning.
Good to see you all. For the record, Kim Canis with the Department of State's Attorneys and Sheriffs. And I think I got scheduled first because we probably have the least to say about this year's miscellaneous judiciary bill at the moment. We know that things change and evolve, so we'll keep track of it. But truly, there's nothing that directly impacts our department. The section 2 dealing with the youth, let's get the name wrong, youth substance, get the name, sorry. Yes, well, I was going to say the acronym, and then I was looking to say the full thing, but yes, YSATs, there we go. We know there's been issues around that, and again, Willa will come in, discuss that. That's their their baby, so to speak. So we will let them speak to that. And that, I believe those were their suggestions for clearing up some of the issues that have occurred. But to Representative Gosselin's question earlier, yes, on the impaired driving, if they fail that course, they're still on the first offense, 180-day license suspension. And then second or subsequent, it's a full year of a suspension. So that's still in statute and doesn't change as a result of this. The addition here just adds, as Legislative Council said, that first A through D, the possession of drinks or cannabis, that creates the license suspension.
If they pass that, they can get
If
it
they
back
pass,
quicker than 180, right?
yes, exactly, yeah.
Thank you.
So that was last year, you all spent a lot of time tying that education piece together with the suspension and came to those time limits, and that is in no way impacted by the change here. We fully support the course of conduct change, clarifying that those two incidents can happen on the same day. I haven't personally run into a judge pushing back on that, but if that is happening, then that's wonderful to clear up.
That's section 9 and 10.
Yes, for the stalking statute, both civil and criminal. So we support that change. I know Jen Pullman will be in and can speak to section 11 regarding the information by law enforcement. I know there's been a lot of work being done to update the form, so you just want to make sure, obviously, that the forms are completely updated with that information before requiring law enforcement to hand that information out in written form. But I know that's been a lot of work that has been going on. So that would just be something I haven't personally looked at the form recently. So I would just want to confirm with through Jen Pullman and or other law enforcement witnesses that that has been updated. But the information to victims, that is a gap that has been identified when folks are detained and victims not knowing how to have that information. So that has been identified and folks have been working on that issue. And this is another step towards that. So we support that.
Chair, I'm assuming we're going to law enforcement weighing in on that one.
Yeah, I can do that. I mean, if necessary, we'll hear from Jen Pullman. My understanding is the form.
They all agreed on.
I think it's already there. I just, this morning, just didn't put eyes on it. So I just wanted to double check, but I believe it's not an issue, but I just wanted to flag to double check that before it goes into law. So many of the cross-referencing in section 23, that's no issue. Yeah, and so far we haven't identified anything, Chair, as far as the effective date, and nothing is impacting statutes that we need to change or procedures.
Any questions for, okay? All right, thank you. That's the witnesses we have for this morning. I didn't want to put too many in case we didn't get to them all. And just one correction, this afternoon is not just miscellaneous bill. We're also going to look at the latest and hopefully last language you need to look at for, of course, debt bill that we've been doing a drive-by for Commerce. So that'll be at 1, and then we'll start back on miscellaneous bill at 2. So we're adjourned until 1 o'clock.